I'm not here to discuss Idaho's discovery rules or offer legal opinions about constitutional standards. Rather, my area of focus is based on my experience, training, and expertise in forensic DNA litigation, and what a minimum practice standard would be for a reasonably competent trial attorney who must comply with their duty to investigate a case on behalf of their client.
And is that because of what you get when you get genetic genealogy?
Well, yes. I mean, forensic evidence is often central in a case, and DNA evidence in particular. And so when there's an item, for example, here of an environmental sample of trace DNA evidence that, as I understand it from reviewing the pleadings, was twice tested, first for an STR profile and then later for a genomic profile. The question becomes, what is the minimum practice standard for an attorney to be effective in their representation of a client given that type of evidence?
When you're talking about two samples happening, or two tests happening, why shouldn't it be know that?
Well, there are a number of reasons why it's crucial for the attorney to investigate any testing of evidence that is central to a case. And again, here it's an environmental sample of trace DNA that is being tested. And so it's essential for the attorney to know, for a number of reasons, about the details of the testing and the investigation when we're talking specifically about forensic genealogy. Number one is there's pretrial concerns. And those pretrial concerns that can be raised would involve suppression issues and potentially Fourth Amendment issues. These are questions that are very much evolving in the state of our litigation. But to understand the viability of a Fourth Amendment challenge, there has to be a factual investigation. There has to be a determination of the conduct that law enforcement undertook during the forensic analysis of the genealogy. So, for example, was it fast and loose? Was there searching of data banks that violated the terms and conditions of those data banks? Was there surreptitious DNA collection from individuals, targeted individuals in family trees? So these are very fact-specific inquiries that the attorney must know in formulating a suppression challenge under the Fourth Amendment, because it's all about reasonable expectations of privacy. And what's really critical here to understand it, and this is close to me from my litigation, early on, the government and law enforcement's argument was always there are minimal privacy interests at stake because forensic DNA profile is like a fingerprint. And it says nothing about who the person is. But now with forensic genealogy, we're talking about genomic profiles, potentially whole genomic profiles, or at the very least a SNP profile, single nucleotide polymorphism profile, single nucleotide polymorphism, an SNP profile that contains a vast amount of information that is very, very private. And so this is a real game changer in the privacy interests that are at stake, and that the attorney needs to understand in investigating the case to assess and to evaluate that suppression issue, that Fourth Amendment issue. So that's one issue pre-trial. There's also concerns about reliability. By reliability, I'm not talking necessarily about the forensic genomic profile, but I'm talking about the STR profile. And again, because, as I understand it from the pleadings, there were multiple tests on the same evidence, environmental sample trace DNA. One produced a STR profile that I understand from the pleadings is represented as being a single source male profile. The reliability of that needs to be investigated, and certainly through one aspect of that is investigating the laboratory documentation that is provided for the STR testing. But we also have to appreciate, and again, I'm not a DNA scientist or a biologist, but I'm an attorney that works with experts, and I need to know what type of expert to hire. And one thing that I do realize in looking at this is when there's multiple tests of the same piece of evidence, and you have a genomic profile, actually the entire human genome that is typed from this environmental sample trace DNA, or at least an SNP profile, which is somewhere in the neighborhood of 700,000 locations of data. What does that tell us about the STR profile markers? So, for example, the STR profile markers, which are typed, are 20 out of 30,000 STR markers overall. And so what I would be investigating with a qualified expert is, one, I don't know from the pleadings if there's a whole genome profile that's been developed for the forensic genealogy, but if there is, that should contain STR markers. What does that tell us about the reliability of the STR testing? Is there any potential for artifacts? Is there any potential for an undetected low-level mixture? Those types of questions that are potentially available to inquire and ask about, where you have multiple tests of the same piece of evidence and it's an environmental sample of trace DNA. Now, if it's just an SNP profile, I say just, but that's 700,000 locations of information that is like a probabilistic future diary of someone's health, medical, and all manner of conditions that are linked to genetics. That may not have the STR markers in it itself, but it will have information, SNP markers in the neighborhood of, so to speak, of STR markers that will also shed light potentially on those STR markers and the reliability of those STR markers. So these are, particularly in a capital case, crucial areas of inquiry that must be undertaken by the defense team in conjunction with experts retained. But they can't even decide what experts to retain without having the discovery. And that's the minimum practice standard. And that's a point that I've made in testimony before courts, where I've been accepted as an expert in Maryland, D.C., and Virginia, that the minimum practice standard is that the attorney must obtain discovery of the scientific testing of an evidence sample. And that, particularly so in a capital case, particularly where we're talking about an environmental sample of trace DNA, it's absolutely crucial to get that discovery, because then that informs the scope of the investigation, the experts to hire, what have you. Now, also with respect to forensic genealogy, it's important not to separate this out into all these different components. It is, you have the S&P testing, and then you also have the development of these family trees, these database searching. This is all part of the same testing and experiment. They go really hand in hand. You can't unravel them. They really have to be considered together as a single cord of different strands of the testing and experiment, because the attorney needs to know how these family trees have been developed, because we're talking now about trial issues, and the government is introducing the STR profile. They have to introduce statistics that explain the significance of any STR match that the government is identifying as central to its case. And so the defense must investigate ways to cross-examine those statistics and the rarity of that match that the government is attaching great significance to. And so an area to look into and to inquire about are the limits of the statistical tool that the government is using or the state is using, which is based on the premise that sort of what's called a random person not excluded. And that's answering the question of the rarity of a profile in a population of unrelated people. But the key point there is unrelated. So we know there's no universe where a STR profile has no relative. And in fact, in a case involving forensic genealogy, the way that the defendant is identified is by searching a pool of related people. And so we need to be able to investigate and evaluate the rarity of a profile within a related population. And that's a different question than what the government answers with its random person not excluded statistic that is typically used. And so, again, without the discovery of the forensic genealogy, both the testing as well as the experiments that are done with the test results, i.e. the database searches, as well as the family tree build out, the attorney can't investigate that. And in that situation, by not investigating it, is not complying with their duty to investigate that is required, especially in the capital case.
And what do you say that when you have sample, in this case, if you have a sample from a thing from an that was STR testing done, and then when you go when you have genetic genealogy testing, you end up with whole genome testing or an SNP profile. Did I understand that?
Yes, and it's unclear to me at this point what type of genomic profile was developed, whether it was a whole genome sequence or whether it was an SNP profile, which contains about 700,000 locations of very personal private information.
I didn't hear you say that no matter which one of those was done for genetic genealogy, that you need to look at those to test the reliability of the STR profile. Did I hear that right?
Yeah, so this is as an attorney and not a scientist, but as an attorney who has a duty to investigate. This now is an area where the attorney will look to retain a qualified expert who can evaluate and assess the linkages between the SNP profile or whole genomic profile and the STR profile. To be sure, an SNP profile or forensic genomic profile can't be searched in codes. It's not that type of situation. They can't be directly compared. But there are techniques that can evaluate if it is a whole genomic profile, you would look to a scientist who then would be targeting the areas of the whole genomic profile that comprise the STR profile. Then evaluate the reliability of the STR profile, the potential for any mixtures, potential for artifacts from the STR profile. Or if it's an SNP profile which doesn't have the STR locations in it, then you would look for an expert who understands that the neighboring regions around where the STR markers can be evaluated and assessed to provide information about what the STR markers do.
Can I clarify something?
Sure.
So what you're saying is that you need to look at the qualified scientist. We have to look at the SNP profile to compare it to the SPP profile for the reliability of the SPP profile.
The STR profile.
STR.
Yes. So there could be clues, absolutely, that could be discerned from an analysis of the SNP or whole genomic profile. because again, we're talking about two different tests of the same piece of evidence. And there have been, in peer-reviewed publication, I mean, one that comes to mind is Jaehee, who published in the journal Cell about how there can an S&P profile can be linked to an its STR profile. And that's by zeroing in on sort of the neighboring regions and examining those. So again, I'm not a biologist or scientist, but I'm an attorney, who has a duty to investigate. To investigate requires hiring experts to examine this data, this discovery that hasn't been produced yet. And so that's why the minimum practice standard is to get that discovery so that the attorney can then assess that discovery and then retain a qualified scientist to help understand the extent to which the S&P testing will shed light on the reliability of the STR testing that has already been done on the sanctions study.
So that having that profile on the S&P can verify the legitimacy of the STR.
Right. So that's my hypothesis. That's what I go to the expert to inquire about. Because again, this is a very, very much an emerging area of forensic science and litigation. Yes,
I'm going to exactly. I don't believe that this is qualified to opine on what's stated in these scientific processes. He just indicated that it's his personal hypothesis. I would remove my objection on that.
Well, I'm going to overrule that because I asked the questions. I apologize. Go ahead. Ask your next question.
When I was talking about either the whole genome or the SNP profile, am I looking for just like a sheet of paper that has a bunch of numbers on it, or is there a packet of information that I need to go to my expert?
No, you need the raw data of the profile along with it's similar to the sort of data that you obtain from the SDR testing. You get the raw data of the profile, you get the laboratory protocols, you get all the bench notes, how the profile was generated, but also you should get the discovery about how the profile was then searched in different databases and family trees constructed.
That was going to be my next question. I heard you say that you can't look at this whole genome sequencing or the SNP in one category and then look at the building the tree identified from the genetic genealogy piece, the genealogist piece, in its own separate areas. That they're not two separate lanes that they combine.
Yes, they go hand in hand. You do one for the other. I mean, they go together.
Why?
I'm sorry?
Can you tell me why? Can you explain why you say they go together, why you don't?
Well, the SNP profile is what is searched in the ancestry database to then identify, potential relatives. And then family trees are built out. That's the object of the SNP testing. What's important to know from a defense perspective in terms of trial work and potential areas of cross-examination, the government is going to be introducing a statistic that is premised on the assumption of an unrelated universe of people. So what's the chance of finding a profile in a population where there's no relatedness between that profile and anyone in that group? And so, as you know from talking about this whole concept of forensic genealogy, people who are related have similar DNA. And so the statistics change when you are talking about a chance of finding a profile within a related pool or related universe of individuals. And that's a legitimate area of inquiry from cross-examination for the defense to demonstrate the limitations of the statistical question that the state is presenting through its expert witness. And to do that, you need to know, for example, who the population of related people are, because often from my work on the forensic genealogy, what I've seen is that when a match is found, when the STR match is found, then all building out all further testing stops on the forensic genealogy side. And so it's important to know who hasn't been tested on the related person side in terms of developing cross-examination about the limitation of the statistical tool that the state uses in its case to demonstrate the rarity of the match that will be done.
Have you received medicolegal journals in your country?
Yes. So, which wasn't surprising to me, because even though typically the government doesn't seek to introduce the forensic genealogy, in its case, it nevertheless is evidence that is a scientific test of material in the case. And so the discovery rules typically call, for example, in Maryland, in the District of Columbia, call for discovery of scientific testing of evidence in a case, and that's regardless of whether the government is going to introduce it or not. DC is a little different, where it requires either a materiality showing or that the item is introduced in the evidence. And so even when there's a limitation on the item being introduced in the evidence, that really goes to the item tested, which here is the environmental sample of trace DNA. And of course, the government has twice tested it. And so for the attorney to be able to fulfill their duty to investigate and satisfy the minimum practice standards, they should have access to the scientific testing of that item of evidence, which is central to the case.
The state is getting, and we are desperate to find out the timeline in this case and when the state knew what and when. There's no question that motions to suppress are coming. Motions to suppress are coming on warrants. And whether or not those motions to suppress are based on Frank's material because misrepresentations are made depends on the timeline. So if there's a representation made in a warrant that things happened in a certain way, if we are able to look at the timeline and say, we know that the state knew this when, that gives us an answer on whether or not the suppression issue includes a truthful statement in the affidavit.